Thank you. Thank you, Chief Justice Rabner, Judge Grant, distinguished participants, and the organizers. Really, you've done a tremendous job here. And thank you for allowing me the opportunity to testify today and participate at this conference on behalf of the League of Women Voters of New Jersey. My name is Henal Patel, and I sit on the board of the League. For over 100 years, the League of Women Voters of New Jersey has empowered voters and defended democracy. The League's mission, both in New Jersey and around the country, is to encourage informed and active participation in government. While voting is the foundation of this mission, it goes beyond that. Democracy is multifaceted and could not function without a judiciary that serves, reflects, and engages the people. This is a principle that the League has long recognized, from being at the center of the fight to allow women to serve and to encouraging our members to heed the call of justice, to heed the call of service. We in this room all recognize the importance of the criminal justice system, of the judiciary, of the justice system completely. Just about everyone here is a lawyer, and law school teaches us well. But one other element that we need to remember, particularly when we talk about juries, is how the judiciary, how the justice system is perceived by the public. Because in order for us to function and function well, we need a system that the public believes is actually just. So our testimony and recommendations today are intended to, one, help create a jury selection system that truly reflects the diversity of New Jersey, so people throughout the state can participate and all defendants may have a jury of their peers. And two, to address the systemic racism and other barriers that not only lead to unfair outcomes for defendants, particularly Black and Brown defendants, but sow distrust of the system in the broader public. So first I wanted to talk and start with, as we learned yesterday, there are multiple layers to get to an actual jury. So starting from the top is the source list and how that's put together and the statutory barriers in it. So the first is the source list, and we talked yesterday a little bit, and I hope to give a little context. One issue that was discussed pretty extensively is the fact that so many jury service notices are returned back undeliverable. And we know that's an issue. I think one of the reasons is that one of the major sources of jury service lists are voter rolls. We have long seen issues in our voter rolls with outdated information, including people who have moved and people who have passed away. Now, we're fortunate, and I want to stress this, we are fortunate in New Jersey that we do not aggressively purge our voter rolls, as some other states do, because that most often leads to Black and other voters of color being removed. However, this does mean, on the flip side, that we end up having voter rolls that are out of date. We see these problems, same problems of voter registration and vote by mail issues. There has been progress, and we're going to see some more. And I hope, again, to just provide a little context for everyone here as we think about this today and in the months to come. First, automatic voter registration and online voter registration has provided voters with tools to update their registrations more effectively, and has been really helpful on that end. This year, a law went into effect allowing New Jersey to join the Electronic Registration Information Center, ERIC. Once fully implemented, which we understand will be next year, New Jersey will be able to safely and securely update our voter rolls with information from other states regarding people who have moved. We're also working with our partner, the New Jersey Institute for Social Justice, it's my day job, to advocate for same-day registration, which has been shown to update voter rolls, improve voter rolls in the states, the 20 states in DC that already have that option for voters. So these voter reforms not only expand access for voters, but they lead to more accurate voter rolls, which in turn can and will lead to more accurate jury pool source lists. However, improving our voter rolls will not alone fix the issues with our source list. The greater challenges are the legal barriers for those who can serve on juries. So the first I wanted to mention on that is one we have talked about a few times today and on Wednesday. New Jersey bars people with criminal convictions from serving on juries for life. That barrier affects hundreds of thousands of people. And as New Jersey has the worst Black to white racial disparity in incarceration in the country, this disproportionately affects Black people in the state. New Jersey recently restored the right to vote to people on parole and probation. This is crucial in recognizing that people on parole and probation not only deserve the right to vote, but that they're still part of our community and should have the opportunity to civically engage. A lifetime ban from serving on a jury hurts the justice system and undermines efforts to civically engage returning citizens. We urge this conference and in the months to come that we recommend ending this practice. The next issue is one I mentioned a little earlier today. Civic engagement and democracy must not and should not be limited to people who are eligible to vote. We already recognize this with our source list because we use lists beyond voter rolls to call people for service. We should go further and acknowledge that many residents in New Jersey are per se denied from serving on juries. Last year, Connecticut Supreme Court convened a task force, as we just discussed, and they ultimately recommended that jury service be extended to include non-citizens, such as legal permanent residents. It was endorsed, including right here, by the Chief Justice of the Connecticut Supreme Court. Over 22% of New Jersey is foreign-born. Now, not all of them are non-citizens, but there is some data that shows that it could be up to from 300,000 to 500,000 people in the state of New Jersey are legal permanent residents. Moreover, then there's other non-citizens here, people on student visas, people on work visas, all members of our community, all members of our state, all people who pay taxes, who we ask to go defend our country, but we denied them a right to serve on this jury. Denying them that right denies them the opportunity to engage in the communities that they live, and it denies defendants a true jury of their peers. So now that we've discussed some of the statutory barriers, I wanted to talk a little bit about some of the systemic barriers, stuff that we've discussed today and on Wednesday. The first being that one of the biggest barriers for service in the state is how little we pay jurors. $5 is so little as to be insignificant. We know this poses a challenge on so many people. While the individual net worth for white people in New Jersey is $106,210, it is just $179 for Black and Latino residents. We must provide fair compensation for our jurors, such as tying jury service to the minimum wage for jurors who do not otherwise get paid for those days. We must also figure out a way to provide childcare. These are issues that affect Black and brown communities the most. Another thing we must do better with is language access. Based on the 2020 census, New Jersey is over 48% people of color. Due to historic systemic issues in doing the census count, we are likely already a majority people of color state, the reality of where we are. Middlesex and Essex counties are two of the most diverse counties in the country. Hudson, Mercer, Union all have significant populations of communities of color. We are doing a disservice to the people of those counties and to defendants in those counties by not providing more language access tools. Earlier this year, the National Center for Access to Justice ranked New Mexico as #1 in the nation for language access in the justice system. In New Jersey, we are actually doing quite a bit. I want to acknowledge that and recognize that. We're ranked 10th, tied with California, which is genuinely better than a lot of people in this country have. However, we can do more. New Mexico coordinates and funds interpreter and translation services, including on-demand video remote interpreting. The program recruits, trains, and qualifies interpreters. They offer a wide range of services, including ASL language classes for court employees, translations of web content, and training court staff to serve as language access specialists who provide out-of-courtroom help to people in their native languages. We should follow New Mexico's lead and adopt a similar program. We know it's not going to be cheap. Neither is paying jurors more. But here at this conference, we should be talking about what we should do and then figure out what we can do. But we really should discuss what we should be doing. Finally, I'd like to turn to barriers, racist barriers that are enacted during the course of jury selection. We have discussed extensively, it is clearly the hottest topic here, the issue of peremptory challenges during this conference. And undoubtedly, we will continue to discuss the issue after today. In Batson, the United States Supreme Court held that excluding a juror solely on the basis of race was a violation of the 14th Amendment. While the decision focused primarily on the violation of the defendant's rights, the court noted that jury selection procedures that purposely exclude Black persons from juries undermine public confidence in the fairness of our system of justice. How juries are selected and who gets to serve on juries is foremost about defendants' rights, true, but it is also a broader issue of democracy. We cannot nourish public trust in this process and thereby hope for excitement and engagement from the public if they do not think this process is fair. We are seeing that right now in the trial of the murder of Ahmaud Arbery. At the first day of this conference, Dr. Rose acknowledged that if and when peremptory challenges are used more aggressively, they can have a racial impact. And we saw, as the chief explained a little while ago, in her data, it was clear that there are certain cases where it is used more aggressively and does have a racial impact. The public does not follow most jury trials. Let's be honest about that. They do follow the most high-profile ones. When peremptory challenges are used by both sides as pretext for race, even in their belief that they're doing it to get a fairer trial, fairer jury, the public doesn't see it that way. They look at the impact and they walk away with views of how the system is designed. As we've seen in various, and we see that it is done, various studies around the country have shown how peremptory challenges are used as pretext for race. It sows distrust in the system for the broader public. Justice Albin earlier mentioned the peremptory challenges lack transparency, and it's in that darkness that public distrust thrives. We need to be more open and transparent if we want the public to trust our system, because public distrust is not just limited to police issues, it's a broader area, a broader issue. Justice Marshall recommended in his Batson concurrence that the only way to truly prohibit racial discrimination in this process is to end the practice of peremptory challenges. We urge this conference to listen to him. Finally, I just wanted to say that jury service is crucial to an effective judicial system, which is foundational for our democracy. We're grateful the judiciary has called for this conference to discuss how we can improve our process. The League is especially thankful to be invited to provide testimony here about how to engage the public and how to reform this process so it is fair and representative of the diversity in our state. Thank you.